May I have your lordship's kind leave to mention item number 81 of today's list, my lord? Lordship will recall the matter is regarding a restaurant in the Salt Lake area. It has been shut down, my lord. My livelihood is at stake. 15 to 20 people have been employed by me. I am not being able. Yes, my lord. Any day, lordship will kindly fix it, my lord. The situation is dire, my lord. Any day. I've already served notice. If lordship takes it up today, my lord.
Can proceed. Yes.
My lord, then may I come back at 4:30 and mention if lordship permits? I'm deeply
My lordship,
obliged.
I am here to mention a matter for substitution. In the matter, Pradut Kumar Kal and State of West Bengal.
Substitution.
Yes, my lordship.
Substitution.
Yes, sir.
My lord, may I be permitted to mention item number 371 of the monthly list, my lord? It is a review application, my lord. My lord, now, my lord, there is a grave urgency, my lord. Some local miscreants, my lord, is cutting my crops, my lord.
All right, hand over the slip.
Lordship, may I be permitted to mention one matter for inclusion? An order was earlier passed.
Motion.
Yes, Lordship, it was earlier passed to be under the heading fixed motion.
Hand over the slip.
Milord, last week I mentioned before Lordship regarding a hearing matter of 2003. Milord, it was time to time heard by Justice Samanto.
Please wait. Please mention in the month of January. Please wait. Because there are few working days left only.
Milord, may I answer? If it is included in the month of January.
Please mention.
Restoration for restoration of the can
Restoration. Hand over the slip.
Milord.
Yes, call the list.
My lord, may I be permitted to mention an old contempt application for inclusion?
Yes, call the list.
My lord,
Yes.
The 3
the matter is very old matter and list out the 2023 and does not listed the matter.
What do you want? Hearing or motion? Please check up, then mention. Yes.
My lord, at my instance, my lord, the matter is appearing under the heading extension of interim order. My lord, I have served notice upon the learned advocate who was appearing for the respondent, my lord. My lord, the interim order is expiring today.
Oh, this was that matter. Where is the?
My lord's previous direction was that this matter will appear along with another repetition
Yes.
WPN.
Other matter has come. অন্য ম্যাটারটা কি হলো? স্পিড পাবে না কেন? 25 এর দি
This is my affidavit of service, my lord. I have
evidence service filed in court.
Item number 4.
Item number 4, my lord.
Lord, I am appealing for the petitioner.
Yes. Mr. Piyush Chaturvedi is appearing for the respondent. Kind of short.
Who is appearing?
Mr. Piyush Chaturvedi, my lord.
Yes.
But I'm also praying for a short pass, which Honorable Chatterjee is leading me, my lord. But he is, my lord.
Passover, then it's difficult. What is this matter?
This matter, my lord, pertains to, my lord, and which my lord has substantially heard it. Not this, my lord, my application of section 5 and 8 of the
All right,
Arbitration Act, my lord.
the learned advocates for the respective
This was substantially heard by my lord. It went back to Justice Shampadatta Pal. My lord, Justice Paul Millard came to this finding that it was substantially heard by my lord. That if I'm not, it was released. But assigned for my-
Asun.
Lord, I am for the petition.
Yes.
Item number 5, my lord. I appear on behalf of the state.
My Lord, pursuant to an order passed by His Lordship Honorable Justice Judge Sengupta, the SDO Tomlu passed an order, my Lord, which is page 20 and operative portion is 22. Accordingly, the Secretary Purba Medinipur Jila Parishad and Subdivisional Official Irrigation Subdivision Purba Medinipur is authorized to demolish the illegal construction over the land of the petitioner. My lord, I have filed appeal before the collector district magistrate, which is pending before the DM. Not a single date has been fixed.
When have you filed the appeal?
My lord, I have filed it on appeal filed on 16th June 2025.
My lord,
My lord, and
You are for the?
petitioner number 9, my lord.
Yes.
My lord, DM is not the appellate authority. Appellate authority is the commissioner of Marwan Division, my lord. Sir,
my lord,
This
my lord,
DM is not the.
no.
yes, my lord. When
my lord, second,
SDO
second,
when
second, my lord.
SDO passed order, DM is the authority.
Sir,
When DM passed,
This is under
then
which act?
62
premises unauthorized occupant.
1962, I do not have determination.
my lord,
Is it 1962 act?
Yes,
my
sir.
lord, it's a land matter, my lord.
1962.
My lord, I have filed it in land matter, my lord.
Sir, I do not have, you have not taken, that's the difficulty. You are not checking the determination.
My lord,
Please see the determination.
another determination is there, but
So,
my lord, it's a land matter.
Determination
My lord, kindly
so
consider.
that act has not been given to me.
My lord, on 9th they will demolish. My lord, kindly give
Yes,
some
sir.
Sir, I do not have determination, you are not understanding.
শুনবেন কি করে?
That's the difficulty.
my lord, earlier, my lord justice.
Sir, do you know
said-
in which court this determination is? You don't know, you have not checked up.
my lord, 551.
Then
My lord,
why have you filed before this court? It's a new motion
my lord, earlier
for want of
90
determination. Yes.
Item number 6, Mr. Sanjay Sai is appearing for corporation, my lord.
Yes,
Yes,
yes. Who is for the petitioner?
For the petitioner, my lord.
Yes.
Yes, personally, difficulty has not come today, my lord. Only paying for not today only.
This
Yes,
is
but
my application for extension of mining lease, my lord.
the learned advocate. Yes.
My lord, affidavit of service. My lord, the private respondent constructed unauthorized construction.
We're having the instructions, madam. Yes.
My lord, this matter regarding unauthorized construction over the PWD road.
Yes.
My lord, the petitioner made representation before the authority.
Private party, private respondents are there.
Yes, lord.
To serve.
Served, lord.
Immediate service.
Yes, lord.
All received.
All received.
Yes.
Lordship, kindly page my representation, lordship, page 18, annex of P3.
Page.
Page 18, lordship.
Yes.
Kindly consider my representation, lordship.
Yes, madam. What is the instruction?
Your Lordship.
Instruction is coming.
Lordship, I'm representing my senior on behalf of respondent number 9 to 13. He is presently in Rampur Hatpur, so for not today.
Petitioner.
I am for the petition, my lord.
Yes, my lord, item number 8, my lord, Mr. Sushant Mukherjee appearing for. Just yesterday, brief has been allocated, my lord, message has been
Yes,
given.
yes.
The matters related to the encroachment upon the PWD land in front of the
My lord, kindly check it on Monday.
land, my lord. I made the representation.
ফোনটা দিয়ে দিন। Yes,
Lordship, extremely grateful, Lordship.
Brief
Thank
has
you.
not been
I made the
allocated.
representation upon the assistant engineer, page 50, my lord. 50.
The private respondent
All are served, my lord.
served.
Yes, ma'am. Page 50 is a representation, ma'am.
Where is your representation?
50. Page 50, 50.
আসুন। কিশোর Yes, civil suit is there, Mr. Chatterjee.
Lordship, I appear for respondent numbers 1, 3, and 5. There's a civil suit pending as your lordship, as it's fallen from your lordship. Lordship,
The appearance
Lordship,
of the learned advocate for the petitioner.
their name has not even been mutated. Page number 56 is testimony to that.
Well, let me place my case, then will all this will come.
So you have not disclosed the civil suit, Mr. Chair.
Yes, it's not written in my writ petition.
So I asked, you said no civil suit.
There is no bearing of civil suit in this case. But I have
Lordship,
disclosed
it's a,
You whether there is a civil suit, you said no.
but I thought my lord is finding relation. But there is no relation.
it's not even maintainable at the outset, your lordship. With all humility, your lordship.
Yes, Mr. Chatterjee.
Now, my lord, what happened, my lord? Under the Railways Act,
Under
under the
the
Railways Act, my lord, the dark number in question, my lord, is acquired. Now, my lord, I am running, my lord, a sweet shop, my lord, over the plot in concern. Now, my lord, I have purchased the plot 2 decimals, my lord, from the predecessor of the, my lord, private respondents. My lord, I applied for mutation, my lord, that is pending. My lord, in the
Case has been disposed of.
Madam, please allow, if both of you make submissions at the same time, it's difficult to understand.
Now, my lord, the mutation case, my case is rejected. I went up in appeal. Now, my lord, that appeal is pending. Now, my lord, what happened, my lord? I allege, my lord, the authorities under the Highways Act, Railways Act, my lord, when they are acquiring, my lord, without complying with the provisions of the, my lord, acquisition as enshrined under that act, my lord, they have, my lord, come here to demolish my shop. Now, my lord, on the pretext, my lord, simplicity, a notice has been published in Gazette saying that it has been acquired. My lord, but the act says otherwise, that before taking possession, you have to comply with certain rules. Without complying that, you cannot come and take possession. My lord, I am on that. My lord, why? My lord, this act says, even you have published a notification. Kindly take some.
Who is appealing for the railways?
Lordship, I am appearing.
You are for the railways?
Yes, your lordship.
My lord, kindly takes up the notification first, then take, my lords, the act.
Yes.
My lord, kindly takes up. There are 2 notifications
Where
here.
is the notification?
My lord, annex to the writ petition kindly comes to first notification at page 70. Well, this is in compliance of section 20A subsection 1 of the act.
Yes.
Now, my lord, section 20A subsection 1 gives an indication that they are going to acquire. This is not the acquisition. Now, my lord, this requires, my lord, objection from, my lord, parties interested if they are objecting to the acquisition. Now, my lord, I made a
So
representation.
this notification under 20A was published.
This was published. Then kindly turns to, my lord,
So, which is your plot?
my lord, dag number 395.
395 was acquired in full.
Full. Yes. My lord, kindly turns to page 71, 5th serial number.
Yes.
Now, my lord, subsequent notification which was published is at page 84. The English version is at page 84.
84.
The English version is at page 87. But this is the notification, my lord, where they say under 20E subsection 1, they declared the plot to be acquired and vested with the central government. No.
1, 3, and 5.
So the statute says that upon 20E2, it vests upon the publication of the notification in the official gazette.
Yes. Now, my lord, my grievance starts.
No objection has been it has been made.
My lord, my grievance starts after this. The provision which has been violated is after this. My lord, the process of
Vesting took place, Mr.
vesting
Chatter.
took place, but they cannot take possession. Kindly.
What's the difference between vesting and
No,
taking possession?
I'm just taking, my lord, to the provisions now, my lord. Kindly takes up, my lord, the act.
Yes.
My lord, kindly takes up chapter 4A, which deals with the, my lord, this is special act, my lord, land acquisition act will not apply. Now, my lord, kindly turns to, my lord, 20A, my lord has seen, they have declared. I'm not troubling my lord with that. Kindly takes up section 20H first. What has got 20H?
20H.
Yes.
Yes.
The amount, subsection 1, the amount determined under section 20F shall be deposited by the central government in such manner as may be prescribed by that government with the complainant before taking possession of the land. Now, my lord, before taking possession, my lord, the compensation has to be deposited. Now, my lord, why I am taking, my lord, 20F? Kindly turns to 20F now. Subsection 4. Before proceeding to determine the amount under subsection 1 or subsection 3, as the case may be, the competent authority shall give a public notice published in 2 local newspapers, one of which shall be in vernacular language, inviting claims from all persons interested in the land to be acquired. So, my lord, I am the person interested. I have shop rooms there. My lord, my family business is running from there. So, my lord, unless this is complied,
Mr. Chatterjee, your name is yet to be recorded in the record of rights.
No.
How do they know that you are the interested person?
Now, my lord, this is, my lord, where, this is why, my lord, this is different from, my lord, Land Acquisition Act. My lord, this act has been created, my lord, so that all persons, my lord, who are being interested in the land, my lord, have a right to approach before the authority to, my lord, say that I have this right,
How do
I am
they know?
entitled.
Mr. Chatterjee, till now there is nothing to show that it has been recorded in your record
No,
of
my lord,
rights.
I have written them letters, my lord, before the.
Your predecessor's name is in the record of rights.
Yes, my lord, I have written them letters.
If you have a difficulty with regard to any apportionment claim.
No, it's not about apportionment. It's
So
not
till
about
now, so
Well, there are
is
two
a violation of the provisions.
There are two
of
aspects. Well, two aspects. Well, one is Milord notice under Milord gazette notification. Second is before taking possession, you have to Milord comply with this local newspaper publication, so that all person interest will approach you. Milord, if this is not done, Milord, today my shops are being broken. Today they will say.
Where is the provision for this?
My lord,
give a public notice before
20F3.
proceeding to determine the amount.
So, Milord, tomorrow if my shops goes, they will say there is a vacant land.
कॉल करती रही
And Milord, simultaneously reads with Milord, now Milord 28 subsection 4 and 20I.
28 subsection 4.
Now, Milord, it is the duty of the competent authority, if there is Milord dispute, as was rightly pointed out.
This is with regard to the apportionment.
Apportionment.
That is
Yes,
what I
this
was
is there.
telling you.
So,
If
Milord,
there
there
is a
is.
dispute, let an
They
award
will
be
refer
passed.
it to.
After that, you can.
Yes. So, Milord, first 20F4 is not complied. They are not published in local newspaper. You come. Second is Milord 20I.
20I.
Yes.
Where you will end, Mr. Chatterjee, you have proceeded up to I. Where you will stop?
Kindly, may I just place it?
Yes.
Wherein land has vested in the central government under subsection 2 of section 20E and the amount determined by the company under section 20F with respect to such land has been deposited under subsection 1 of 20H with the
So
competent
according to you, after it is paid or deposited, then
Milord, they
then
will
the-
direct the owner as well as other person who may be in possession of such to surrender or deliver possession. Milord, they just cannot come with excavator and Milord demolish shop rooms.
Yes.
Milord, this is the power of eminent domain has to be Milord exercised Milord as per Milord the law. Milord, this law Milord of acquisitions Milord are Milord draconian for us as well as for them. They have to comply with each and everything.
यहाँ तो बोला है no objection.
These are expropriated laws. So Milord, non-compliance of this today with an excavator standing on my land.
Till now it has been
Milord,
been demolished.
Not yet. Milord, just my adjacent shop rooms are being demolished. Mine is just Milord standing facing me.
Yes, madam. What is your
Lordship, first of all, the shop is not mutated in his name, Your Lordship. Page 56 is testimony to.
Complied with 20F4.
Yes, Your Lordship. Your Lordship kindly sees page 87, Your Lordship.
Page 87.
Yes, Your Lordship. The second paragraph, Your Lordship. I will place that. And whereas the substance of notification number so and so dated 9 July 2025 was published in the daily newspapers, namely Bortoman Bengali edition,
So where
dated
where are you reading?
second paragraph, page 87.
Substance of the notification number 2696. What is 2696?
2996, Your Lordship.
Yes, 2996 page
87.
No, 2996.
2996. Where is 2996?
2996.
Notification is not.
My lord, 9 July notification just I have shown, my lord.
The
The
Show me
previous
that you have complied with 20F4.
not complied.
Then 20F4 and 20H. So after payment of compensation or depositing, then you can take possession. Show me that. That 20H has been complied with. Show me that.
Who do we pay to?
Then it comes power to take possession. Then you have to direct the owner or any person to deliver or surrender possession. Show me that you have followed these steps.
Your Lordship, this brief has been allotted to us yesterday night, Your Lordship. The railways have instructed us that they have still not received a copy of the brief. They have actually asked us to seek time, Your Lordship.
Then you have to undertake that you will not demolish. Because
You-
these are the provisions.
Your Lordship will kindly post it tomorrow. In that case, Your Lordship, kindly post it tomorrow.
Tomorrow will be available.
Oh, sorry, Monday, the next day, next working day. Kindly, Your Lordship.
But till that time, don't take any steps.
Yes, Your Lordship.
Lordship direct.
Till the next date of hearing. Till the next date of hearing.
Till the
Next date of
yes, till Monday.
Monday, Your Lordship. Yes.
not till Monday. My lord, till from Monday, my lord is not here.
So what?
Then my lord,
Oh.
it will be my lord.
So what?
Matter will appear.
Monday list করাতে না পারলে মুশকিল হয়।
হয়ে যাবে।
Kindly till the next date of hearing. I will be in trouble, my lord. My lord will be not here from Monday. My lord, I will be in Monday. My lord, list will come out. Who will having that determination?
Report will be there.
Yes, but there will be list on Monday that who will be having determination. Then I have to mention. Then his lordship will take it up. My lord, at least 3-4 days will go. Then my lord will again come back. So it's still the next date of hearing.
Your Lordship will kindly post it on Monday, Your Lordship. I'll come back with instructions, Your Lordship.
This is my affidavit of service, my lord.
Your Lordship, Mr. Sukumar Bhattacharya is appearing for Union of India.
Who is appearing?
Sukumar Bhattacharya, Your Lordship.
Yes.
The copy has not yet been served upon the council, Your Lordship.
My lord, I think she has been mistaken. The copy has been served, my lord, according to
In the
their
office, Your
instruction.
Lordship, but not upon the council.
He has not received. The council has not received.
Yes, Your
Making
Lordship.
it not today.
My lord, deeply obliged.
Not today, next.
My lord, can it be, my lord, Tuesday, my lord? As per your
Tuesday.
lordship's convenience.
ওটা টিউসডে ডেটটা মার্ক করে রাখুন, কিছু করতে হবে না, শুধু
Deeply obliged.
My lord, my lord, I will come back on Tuesday, my lord. My lord, actually, everybody has already been delivered, but the private respondent has not been delivered till date. My lord, this is the track report, my lord.
private respondents not served.
Yes, sir, the served not delivered. I have
Sent, not served.
Yes, my lord. Yes.
The learned advocate appearing for
Well, my lord, I am for the petitioner, my lord.
yes.
But all copies have been served, my lord, especially on the, my lord, Jela Porishad.
My lord, all the parties are not relating to the land. All
My lord,
are
may I-
panchayat,
my lord-
and action of the panchayat is Jela Porishad is my lord under challenge.
No, I
And-
could
and
not follow.
My lord,
all
may-
the,
what
my lord,
is-
if your lordship kindly come the, my lord, the.
My lord, Panchayat is also
name
a
of
party,
the
Pradhan has been
respondent.
served as well. Pradhan
What is your
Panchayat-
allegation?
Allegation has-
Against the Pradhan and the Jela Porishad. How the land, in the land jurisdiction it will come.
My lord, my lord, road is being constructed. My lord, may I submit, my lord?
Paragraph 13.
Sir, एक second, sir, बोलो नहीं. My lord, may I submit?
What is the dispute?
Dispute is, my lord, land is, my lord, tender has been floated, my lord, by the Jela Porishad. My lord,
How it is a land matter?
my lord, may I? Tender has been floated, my lord, by the Jela Porishad for construction of a road, and and my lord, the point of construction has been given, no other particulars. Lordship kindly takes up the tender once, page 30. Page 30 is the tender. Kindly see, Lordship, the work items, the title, and the work description. It's for, my lord, repair and upgradation of a road from Ghonorampur Bhimchok Kali Mandir to Olive Hoja's house under, my lord, Bondipur to Gram Panchayat. Now, my lord, the dispute is, my lord, that there is no existing road as such. The only way the road can be constructed is through my land. And my lord, no process of, my lord, acquisition or any other process pending.
It's a group 5 matter.
Group
How
five,
can it be a
kindly,
group 5
kindly, my lord,
matter?
my lord, this relates to, my lord, construction of a road, my lord, under.
It's an inaction on the part of our authorities
Panchayat
under
and
the
Jila
Panchayat
Parishad.
Act.
My lord, this will, my lord, kindly consider, my lord. My lord, ultimately, my lord, if road is to be constructed, it has to be-
Everything stands on the land.
my lord, just
Then
yeah,
all matters will
All
be land
matter will be
matters.
land.
it
If
has to-
your submission is to be accepted, then all matters will
All
be land
matter,
matters.
This is not a,
education,
my lord, this is not a
The-
tender, my lord,
What's
kindly
the
consider.
action you are challenging an action of the authority under the
and
Panchayat
tender,
Act.
and tender issued by the Jila
Tender
Parishad.
issued by
My
the
lord, kindly
Panchayat
consider,
authority.
my lord, this is not a tender, my lord, this is a specific tender for construction of a land which is to be acquired under this act,
Maybe.
under the act of
Everything
2013.
is on land. There cannot be
But
anything
ultimately,
without
the
land.
dispute will, my lord, come up, my lord, in terms of, my lord, acquisition process. Whether acquisition process has been, my lord, initiated, or, my lord, 2013 act, my lord, under, my lord, any other act. Whether, my lord, land has been acquired, and after the acquisition process, whether the road is being constructed. The
It may not have to be gone to that stage even. If there is a violation with regard to the tender, that will be set aside.
My lord, dispute will ultimately, my lord,
So,
eventually,
show
my
me
lord,
your
it will-
prayer. What is your prayer? What have you challenged?
my lord, written, my lord, multiple representations. Kindly seize, my lord.
They have seen, my lord, that
Tender
My lord, and
the
my lord,
petitioner has challenged. because after this change, you have to again
Yes.
serve.
Everyone is
Panchayat
appearing,
is
my lord.
not here.
Panchayat is not here.
So,
হ্যাঁ দিলাম এভিডেন্স দেওয়া হয়েছে
service taken on record. Yes. Great. The senior advocates are waiting.
No, not for that.
Senior advocates are wait করছে to pass over.
প্রথমেই দিলাম
Because
Yes.
now for
What is the grave urgency that it brings all the senior advocates?
Sir, your lordship has heard this matter substantially. That arbitration matter was where the originals are uploaded with my learned senior friend's client and the court rejects it.
Sent to mediation.
Yes, it failed. Then after that, it appeared before Justice Pal Miller or Justice Shorkar, I forget. Miller.
Justice Pal.
Pal. Where both of us said that your lordship had Miller substantially heard this matter. So it's better, Miller, that your lordship hears it. Your lordship found some interest in the matter as well. Because that was the observation made. And now, Miller, everything is there
Interest created by
Mr. Chudh.
both of you.
I cannot. Still, any day for hearing. This will take a little bit of time. My lord comes back from Ahmedabad. The only interim order is till the next date of hearing.
There is no interim order.
No.
There was an understanding
Yes.
that they'll pray for time, and my lord, we shall not oppose it.
Yes.
My lord, I continue to do it.
The same way, my lord, it's been passed. Your lordship, my lord, extended. And kindly fixes a date so that it can be heard out.
On which day
10th
this
is the next date, my lord.
no. On which date this order was passed, that will then
My lord,
understanding whatever.
27th August 25.
And that was extended from that.
27th of August.
Yes, kindly see his internal page 2 of the order.
That's what it is, yeah.
Now, Mr. Chatterjee, what will be done in the meantime?
The 10th, my lord, is a date where, my lord, I will have to use my
Written statement.
I don't want to do it.
Written statement.
That is exactly why your
Should
lordship.
specific performance of contract.
It is for, my lord, getting back the documents.
Mandatory injunction.
Suit for declaration, mandatory injunction, my lord, asking for the documents being the subject matter of a development agreement. There, my lord, a Section 8 application was filed, my lord, it was rejected. Then an appeal was preferred therefrom, that was also rejected. Against that, a revision. Lord, may I take my lord's short leave?
Item number 13. Yes, where is your other side? Pass over next. Item number 14.
My lord, 14, I appear for the respondent. My lord, your lordship had kept the maintainability point open yesterday.
Maintainability point open. Why?
Yes, my lord.
What is this matter?
Matter is I was inducted as a licensee, but pursuant to the legal licensing, and regularly I was paying rent on the terms and conditions of the thing. Now,
The decision of the hearing was not communicated.
Yes, yes.
What is your
My lord, why I say, my lord, that the writ petition is not maintainable? On the very first point, my lord, that
you have heard him? Have you communicated the decision?
my lord, that is what I'm saying, my lord, that this is why this is premature. My lord, kindly see my demand. Demand is of 8th September. I say that you have not paid this amount. Kindly come for a personal hearing.
Yes.
Personal hearing was held.
Yes.
My lord, thereafter, prior to the puja vacation, my lord, thereafter he issued a representation. My lord, after the hearing,
September 16, 2025. Today we are in December.
yes, my lord, after the hearing, we have not raised any demand. We have not. It is not a situation.
No, where is your decision, sir?
My lord, that
May
is
not
what.
give up, may not have
That is
raised
what
the
my.
decision.
That is what
You
my.
have taken a hearing. Where is your decision? Have you taken a decision?
My lord, that decision is being taken, my lord. It has not been taken.
How long you will take? 1 week?
My lord, my instruction is, my lord, at least 8 weeks, my lord. 8 weeks.
8 weeks? Why?
My lord, my instruction, my lord. My lord, kindly visualize the situation, my lord. They have vacated the they have vacated the flats. My lord, one minute, my lord. They have vacated the flats. I have a demand.
Yes, yes, yes. If you have a demand, so that demand
My lord,
cannot.
I have to initiate proceeding.
Yes.
My lord, they will have a right of say. My lord, why I say that your lordship need not pass any order. My lord, if it is my demand, my lord, demand of a sum money. Now I have to initiate proceeding against him. He will definitely have a right of say, my lord, whether it is a fair rent, the revision of rent. My lord, in 2023, HIG flat 18,000 rent has been fixed, my lord. Now whether it is reasonable, your lordship sitting.
No, only one thing. Then I do one thing. Yes. Till now, you have not passed any order.
Yes.
So I will say that you take as much time you want, but no coercive steps in the meantime. I'm disposing of this writ petition.
Well, coercive step, my lord, where is the chance of coercive step?
That is why. So that is why no coercive steps till 2 weeks.
My lord, I can.
After the communication.
I can initiate legal proceeding, my lord. That cannot be a coercive step.
Then you will communicate the decision.
Yes, my lord.
Challenge.
My lord, kindly give us some
You can
time.
do that, but you have to communicate the decision.
Yes, my lord.
Till 2 weeks thereafter, you will not take coercive
My lord,
steps.
kindly give us some time.
Look, today, tomorrow, pass an order. He has to be given some time to challenge that if
Yes.
it is against him. So protection will not initiate any coercive steps for a certain time after the communication of this order.
My lord, coercive step, my lord, in the sense because I have a right to file any legal proceeding against him for recovery of money. What coercive step I can take, my lord? They are not.
Without disposing my grievances. So he will take.
But you communicate this
My lord,
decision.
whatever he is saying, he will say that before the court.
How much time?
My lord, that is my instruction.
Authority takes to take a decision 16th of September.
My lord, I leave it to your lordship, my lord. My instruction is 8 weeks. I leave it to your lordship, whatever your lordship.
So you communicate 16th of September. So you communicate on or before 22nd of December.
My lord, kindly next January, my lord, any day.
It's more than 3 months you are taking. 16th of September, it was hard. You will not be.
I don't have any problem. Only thing is, can I satisfy for 2 minutes? But they have the condition precedent was they will raise invoice, I will pay. This is not their case that they raise.
Mr. You have raised all these points in the representation.
Yes, all the things.
Yes.
Let them decide that.
Yes.
So let them take a larger time. We will not be affected.
Let them take 8 months, 8 years. No problem.
My lord, that is what I'm saying, my lord, that after the hearing, I have not demanded any money from him because I have to take the decision. Not kindly record my submission.
There is a demand.
Where is that
My
demand?
lord, my lord, demand before the personal hearing, my lord,
All
after.
right, so you will not give any effect to the demand base. In the till
Item number 1.
where is Mr. Uttam Bhattacharya? Yes, Mr. Supratim Dar. Supplementary list. Report. Look at the order. Mr. Uttam Bhattacharya, why are you not here?
Go.
Brought the brief. Not today. Yes.
I have prepared every judgment. Everything is ready, but I have
Matter.
yes.
It was not today. Yes. Next.
Item number 15.
My lord, I am for the 15. My lord, this is the affidavit of service. My lord, I am the absolute owner of a land measuring about 40 shotaks by way of purchasing sale deed, my lord. Thereafter, in the year of 1988, thereafter in the year of 2016, when I went to the Noihati ADSR office to transfer my whole portion of land in favor of my daughter by way of gift deed, then the Noihati ADSR told me that no, I cannot transfer the whole portion of land because out of 40 shatok land, 11 shatok land has already been recorded in the name of WDI. Entirely beyond of my knowledge, my lord, and the respondent authority already constructed the boundary wall upon my land and they are utilizing upon my land without giving any compensation or without giving any notice to me, my lord.
Yes, Mr. Dhar.
Now can we come to the representation, which is at page 29.
Yes.
The relevant portion, my lord, will find at page 30.
Yes.
The crux of the matter.
Yes.
That para 1 and 2 only. 40 shatok used to be the owner. Then died husband passed away on 24th September 2000. Thereafter concerned about the legal obligations, my husband such and such, thereafter on 18th January 2016. So let authority consider the representation first. Kindly read the entire paragraph 2. This is the cause of action.
You have purchased 40 decimals.
40 decimals.
Where is the record of rights?
My lord, this is my fault, my lord. I could not record my right, my lord, because my lord, my
Why?
husband, my lord.
88 you have purchased, till now you have not recorded your name.
Yes, my lord.
Catch is somewhere.
Of the land, my lord. Only it is in my name, my lord.
When acquisition had taken place, whether it was a vested land, well, several issues could crop up. Let the authority first decide.
From whom your husband has purchased?
From
Danny.
Jitendranath Sarkar.
From
Jitendranath Sarkar. Kindly see page 15.
জিতেন্দ্রনাথের নামেও তো পর্চাটা লাগাতে পারতে, সেটাও তো লাগাও। কিভাবে বুঝবে? বোঝা মুশকিল।
কবে ভেস্ট হয়ে গেছে তার কোনো
আরে ভেস্টেড না অ্যাকোয়ার্ড কি?
Yes, yes. You have not annexed all the pages of your deed. After page 16.
Yes. Neat.
Oh, this is the type copy.
15, 16, then page in my.
16A is not the type copy of 16.
Yeah.
16A is not the type copy of 16.
Yes.
Income tax আগে নেই।
Yes.
What is your plot number?
My plot number is, my lord, 553. 553.
Which plot?
দেখো 16 এ কিন্তু এই প্লটটা নেই, দেখো
553.
553.
So you cannot be the owner of 40 decimals of 553.
No, my lord, there are two.
Sir, these two plots even do not make 40.
No, my lord.
Please kindly come to page 17.
No, that.
Plot number 454 and 455 is 27 plus 2, 29.
Yes.
And so there are other plots. Total is 40. So 533 is not 40.
No, my lord. My lord.
But you have said 533 is 40. You have said 533 is 40.
My lord, kindly come to my lord page.
Where is the deed? Please show me the deed. Please show me the original deed.
Original deed.
Because
Now I don't have, my lord.
because the schedule, first schedule is not here. First schedule is not here. Some pages are missing.
In my petition, my lord, I have the original deed, my lord.
But petition is the copy. Show me what are the other two plots. Because page 27. Please see page 27. There are only two plots. 27 plus 2, 29.
29.
So, and they are saying, yes, they are saying 29 you can transfer. So this is the 29.
No, my lord, kindly see at one, my lord, 26, page number 26. Kindly see.
Yes,
From bottom. Kindly see the vote.
yes. 553 is 11, not 40. 553 is 11, not 40.
Kindly come to the plot information at page 28. What my lord has said, that is there. In page 28, the অংশের পরিমাণ my lord will find. And
11
on
decimals.
And on the right hand side, জমির পরিমাণ 11 decimals.
Yes.
Yes. This is my client, madam.
And that has been vested to the West Bengal Industrial Development. It's recorded. This was recorded as per the information in 2016. What were you doing for 9 years? What were you doing for these 9 years?
Not know, my lord. My lord, I am relying upon this order, my lord. When this order passed by this honorable court, then, my lord, I came to know, my lord.
Which order?
একদম আমরা পাশের জমিটা হয়েছিল সেইটাতে ও জানতে পেরেছে।
Or
even the parties are not there. Special land acquisition officer, if it is a case of land acquisition, then some land acquisition authority should be a party to these proceedings. I cannot see anybody. The ADM, oh yes, my lord, respondent number 3 should have been the special land acquisition officer, and my lord could have directed the respondent number 5 to assist the or be present at
who
the
is
time of.
appearing for the West Bengal Industrial
Yes, my
Development?
lord, I am appearing.
Yes, what is your instruction?
No, my lord, what has happened, my lord? Government, my lord, government acquisition of this land. After that, my lord, West Bengal Industrial Development, government handover to the West Bengal Industrial Development Corporation. Then, my lord, after that, my lord, whoever, my lord, the industry made an application for land to the West Bengal Land my lord, Development Corporation, they have allotted this land.
So it was acquired.
My lord.
When? When possession was given to you?
I don't know, my lord. I take inspection, my lord, but verbally, my lord, inspection from my client, my lord. This is the procedural part of this.
Sir, Dhar file a report. I think I'm directing him to add the special land acquisition officer.
His grievance is that he's represent first time. Let him go before the authority. Let Mr. Adok's client be present. Everything will come up.
If it has been acquired, Mr. Dhar, special land acquisition officer, is the best person to say whether it has been acquired or not.
Yes.
So let us see from there, instead of going, those authorities will say we do not have any records. Special land acquisition officer will be having the records. Or I can do one thing.
You can direct, my lord can direct special land acquisition officer to consider his representation, and at the time of hearing, his client would be present, as also Mr. Adok's client would be present. Everybody will produce the respective documents, and special land acquisition officer will pass an order on that basis. If the land was acquired, if not acquired, then everything will come up. If it's been utilized without paying compensation, even that will also come up.
He was informed that it was acquired. So what paragraph 4?
From the kindly
He
come.
was informed, and it appears so. Your learned friend is also saying that he was the requiring body. You file a report on the prayer of the learned advocate.
Item number 16. I have for the respondent number 1. But I am for the respondent number 2 and 3.
But I am for the respondent number 1, Union of
Why?
India. But I am for the Union of India in this matter, my lord.
Yes, what is the representation for?
The
Laying of pipeline.
allegation that we have violated an injunction of a civil court. They have gone before the civil court, made 3 individuals parties. We are not a party there. They have said they are basically workers of our contractor. They have obtained an injunction behind our back. Now they have not made those 3 individuals a party here. Their allegation is we are violating that injunction. When we came to know of this suit, we went and filed order 1 rule 10, got ourselves made a party. We have filed an application that the suit is not maintainable because not any grievance with in relation to that is, my lord, statutory remedies available under the act.
No, what are you doing? Are you laying pipelines?
It is already laid, my lord. Pipeline is functioning.
So compensation?
My lord, compensation has been awarded. It is lying in the name of the predecessor in interest. They say that there is a gift deed. So they have to come forward with the papers, show the gift deed. If they have any objection on the compensation, then they can go before the statutory authority. They have done nothing. We have filed our...
Authority is there.
Yes.
District magistrate.
Yes, my lord. The district judge. If you have any competent authority, is district
authority is the district magistrate.
Yes, in this case, my lord, it is the special LA collector.
Oh, special LA collector.
Yes. And after that, if they are not satisfied with that compensation, district judge is
that
the
has to be referred to
appellate
that.
authority. Yes.
Or dispute as to apportionment also
Can be referred to that. We have, my lord, assessed in the name of the predecessor as per the record of rights. That is, they have not, my lord, mutated.
their names.
Yes, so they are free to go with the documents. If they have objection, they can raise it. If they want to collect the compensation, they can collect it. We have placed all these facts before the learned court below. There was one suit, my lord, we were aware of. We have made ourselves a party. There is a second suit which we became aware of from the petition. 2 suits they have filed on the same cause of action. They say they are
Against the private party, they are the co-owners.
Co-owners. Second suit also, my lord, will now take steps. We have come to know.
Yes, because there is basically they are there for considering the representation. So
representation is we have violated an injunction. That also, my lord, appropriate remedy is there under the, and we are not even party to these injunction orders.
Representation.
Page 145. My lord, kindly takes from internal page 3 of the representation at page 147. Their grievances we have violated this, which we are not even aware of.
When the pipelines were laid?
Already laid.
When?
My lord, sometime in the year 2024. After that, my lord, it has been commissioned. Fluid is going under there. No one is entering their land or anything because, my lord, it's under the ground. There's no disturbance on the surface.
Because
yes,
for the user, they are entitled to compensation because it's not an acquisition in that sense. Because they can utilize their property.
And my lord, I had taken instructions. Even the equipment for controlling the flow and everything is not on their land. So there is no question of entering their land or disturbing anything now.
But at the time of repairing and other things, you will also have to enter and you will also have to.
That
so
right.
Compensation is only for that.
Yes, my lord. And that is already assessed. It is lying with the. We have paid it already, my lord. It is lying in the account. They have not approached for that.
Yes, madam. What do you say? Short? Where is he?
Number 1.
Passover.
What time, your lordship?
12:30?
Yes.
I'm grateful.
Yes.
For the state, man.
For the
state.
State. Yes. Regularize the encroachment. Section 8. Regularize the encroachment. Section 8.
No, no, his case is some panchayat made a dhalai road on his land. So first the panchayat is the presence is necessary. Whether they have on what
Regularize the encroachment by way of invoke. Yes, yes. Who is for the panchayat? Who is for the panchayat?
তো ওইটাই পঞ্চায়েত রাস্তা করে দিয়েছে সেটাই তো পঞ্চায়েতের দরকার নেই পঞ্চায়েত আসছে না
Service was made. Due service was made upon the panchayat. But the act was done, panchayat has acted is illegal act with the, in connivance with the respondent number 6 and 7, the SDU and video.
Yes, Mr. Ghosh, video.
Then I have now my land senior friend is allegation is in connivance with the video and SDO. Then I have to take instruction from the video and SDO concern.
There is a letter.
The petitioner alleges that the panchayat
I'm for the petitioner, my lord.
I'm for the state, my lord.
My lord, Highway Act, my lord. After filing the retention, authority has taken steps and passing the order, my lord. Page.
order has been
Yes, page 26, my lord.
26.
My lord, thank you. 26.
So it's order under 10.3. Then
Yes, yes. My lord, authority has not implemented this order. I'm kindly see the order.
My lord, against whom they are seeking removal, she has not made party in this petition. Madhumita Bera. 10.3 order has been passed against Mrs. Madhumita Bera. I do not know whether she has prepared any appeal before the district magistrate or not.
the
My lord, acquiring my land without my
Well, this is not that. My learned friend possibly drafted or settled, but you lordship find from the record that private respondent, the writ petitioner gifted the property, registered gift deed. And after registration of gift deed, transfer held in favor of the PHE.
Transferred in favor of PHE?
Yes. Gift deed, they have registered gift deed, they are saying this is acquisition.
My lord, there are two documents. One document, kindly see page 49. Page 49. For the same purpose. Page 49.
This is another person.
This is that agreement between the petitioner and the PA. Page 49. Annexure P6. Kindly come to page 50.
50, yes.
Yes, my lord, from the top, ninth line. উহাতে সম্মত হইয়া এই মর্মে লিখিয়া দিতেছি যে পিএইচই উক্ত প্রকল্পের পাম্পিং স্টেশন গভীর নলকূপ উচ্চ জলাধার স্থাপন করিলে আমরা উক্ত জায়গাটি দিতে সম্মত প্রদান করলাম। উক্ত জায়গাটি সরকারি যাহা মূল্য ধার্য হইবে তাহা আমরা নিতে বাধ্য থাকব। This is the agreement. Two documents are made for the same purpose. Then,
so what is the two document? Where is the other document?
Second document, my lord, that alleged Danpotro. Give this.
Yes.
Page 52. It is the consequence of the first document. At the time of signing that document, that is revealed, that document is gifted. They are the farmer. The land is agricultural land. They have acquired the livelihood of the farmer. Two documents for the same purpose. Both documents should be treated as one. Then there is a notice, my lord, page 47. Acquisition notice by Shahapati. There is acquisition notice.
No, this was an page 50.
Yes.
Is an agreement.
50 agreement.
No, 49. What is page 49?
Agreement.
Where is the signature of executive engineer?
Nothing. And my lord, this is the question
Where is
of
the
law.
signature of the executive engineer?
That is
Unconditional gift deed.
that agreement has been
If
submitted by
both the parties have not signed, it cannot be said to be an agreement, sir. So first document has no effect in the eye of law.
And my lord,
only the second document, which is a registered gift deed, does not say anything.
without condition. Unconditional gift deed.
First document, it's only your signature.
Yes.
They are not bound by this first document. Then
Unconditional
what
gift deed, my lord.
Then kindly see 47, page number 47.
Yes.
This is not applicable in his.
This is the acquisition by Shahapati, the notice. জল প্রকল্পের জন্য সরকার নির্ধারিত মূল্যের বিনিময়ে হস্তান্তর করার বা বাস জমি প্রদান করার অধিকার করছে। That অঙ্গীকার করছি। That plot number 15 is also included.
Plot number 15, yes.
Yes, this plot number owned by me.
Yes.
That means requisition was there. Then page 48, the question of compensation has been sanctioned. by the government.
In respect of others.
No,
Page 48.
48.
No, where is this compensation? 48 does not say of this compensation. This is
What
the
is
administrative, yes, implementation. Implementation of the scheme for this construction.
Yes.
That's a different thing altogether. This is not sanctioning of compensation.
My lord,
Unconditional
they are the
gift.
farmer. Only livelihood they have
Yes,
taken.
question of sentiment or
By, I don't know. My lord, it is very unfortunate that they are farmer, they are not very much literate person. On
They-
the agreement,
then they
did
have to
not
challenge the
sign
gift. Then
agreement.
they have to challenge the gift deed.
Like affidavit, they have
Until-
taken that agreement.
Until gift deed
It
is
is
my
in
lord,
the form of affidavit. They have
challenged and set aside by the competent civil court, that they may not put any question. Unconditional gift deed. Transfer effected.
And give deed, there is no acceptance of the.
So, doctor, all things are fine.
Right.
All your arguments are
Right, I'm right, my lord.
fine. But please consider.
Well, he's working under the project.
No, my lord. No.
করছে না এখন করছিল তো আগে
So, doctor, what can be done?
My lord,
I am adjourning this matter.
my lord, I can tell them do something for
Mr.
do something for
they-
them.
Doctor,
My lord, I shall tell them though they are not
after all, they are
though they are not legally entitled.
Something is there, may not, maybe you may say, but stamp paper, something they have signed.
My lord, they are not entitled, though they are not entitled. But your lordship's observation, my lord, your lordship's, my lord, desire, I shall convey so that they may get some relief. Certainly. But they are not under the provisions of law. These
I'm not saying that.
no.
But
As your lordship desire, my lord, I shall certainly, my lord, tell them do something.
so I'm only adjourning how much time, Mr.
But after 1 week after vacation, madam.
Heard the
for that. Whether they can be provided with job.
I think that may satisfy themselves to some extent.
There is PHE, there are the guard and everything is required.
Yes, because after all, it's in their property, they are the residents of that locality.
Right.
So if something can be done,
It may also be possible.
please look into that if something is done. Yes. Thank you. Yes.
My lord, item number 16.
Yes.
Sam for Union of India, my lord, in this matter.
Yes, 16. Yes.
Well,
Where is the learned advocate for Gale?
So he has gone to courtroom number 38.
Yes.
Well, pipeline installation work has been started without giving me due notice. I had
compensation has been ascertained. It has been deposited in the name of your predecessor in interest. You are the subsequent purchaser. Your name has not been recorded. If you want, you can approach that authority, take steps if you are not satisfied with the quantum of compensation. Law provides, gives you remedy.
My lord, one thing, my lord. My lord, I have instituted a civil suit as well. My lord,
Go and fight out the civil suit.
My lord, there
Why
was
have we approached the writ court then?
My lord, despite the order of the civil court, my lord, despite the order of the civil court, my lord, that my lord will find at page 143. My lord will kindly take.
Yes.
The defendants are hereby restrained from disturbing and introducing.
Yes, so violation of the order of the civil court. Please approach the civil court for violation.
My lord, it is, my lord. My lord,
Implementation also civil court can grant.
My lord,
Violation also that can civil court has the power. Execution of an interlocutory order that also the civil court has
my lord,
power.
my representation.
So please approach the civil court because whether there has been a violation of the order or not, at what time, when the order of injunction was passed, whether prior to that it was installed or after that, since the civil court is insisting about the matter, the civil court is the best forum where these points can be adjudicated.
My lord, my lord, and my representation is also at page
146. Is nothing. Representation is to whom? Which authority will consider whether there has been a violation of the civil court's order?
My lord,
Another authority will say whether there has been a violation or not.
My lord, not just that, my lord, not just that. My lord, the secretary, my lord, without granting me notice, without hearing me at all, my lord, the pipeline
That
was
is pending before the civil court. What's the suit for?
Well, that is the suit for.
So you're getting the relief in the civil court, and if your submission is that this was laid down in violation of an order of injunction, civil court can grant you relief for that. Not only punishment, even implementation, even
I
status
bow
quo
down to
ante,
that, my lord.
everything.
I bow down to that, my lord. I bow down to that. My lord, then, my lord, at least, my lord, just, my lord, kindly ask them to consider my.
They cannot consider, sir. Can they consider and say whether the civil court's order has been violated or not?
My lord, not just.
Why not
that.
approaching the civil courts?
My
Best
lord,
forum.
my lord, it is, my lord, my lord.
Yes. Consideration cannot be directed in a matter of this nature. The civil court's order, whether it has been violated or not, is the civil court which is the best person or forum which can decide on that issue. Even implementation, execution, everything. And who will consider this, whether the civil court's order has been violated or not?
Certainly not. My
So,
lord, no other
what were the facts that were existing at the time of passing of the interim order? It's only the civil court which can decide on that. That is your prayer, that it has been violated.
My lord, my prayer is.
Direct such and such to restore your land to its original cultivable conditions. When the suit is pending, how can this authority direct that? That will be again violation overreaching the civil court. Decisions either way.
My lord, I've instructed, my lord, the pipeline has been installed without any notice to be, my lord.
Sir, it's violation of a civil court's order.
No, my lord. Civil
Give me
court's
your
order.
plaint.
My lord, my plaint is at page. My lord, 131, my lord.
Yes.
Plaintiff is jointly acquired absolute.
কত পড়তো 131 ওদের পিটিশন এটাই তো না
That is 131.
হুম
এখানে তো গিল পার্টি কোথায়?
নেই তো
আছে আছে
131 কোথায় গিল পার্টি আছে?
গিল নেই তো
কোথায়? কেউ নেই।
লেখা আছে তিনজন
all men and agents of Gale dependents.
That is not the party.
My lord, 131, my lord.
Land brokers, land suckers.
All men and agents of gil party. Boyle party. Boyle to not.
You have not implemented all are men and agents of Gale Private Limited. You have instituted a suit in the name of wrong person. How are they bound? You know who is doing, and intentionally you have not implemented the right person. And an application for addition at the instance of Gale is pending in the suit.
My lord, will
And this is an ad interim order of injunction,
this is an
which you are seeking implementation.
Yes. The defendants are hereby restrained from.
So there is no crystallization of the rights of decided that the rights have crystallized. There is nothing. How can this be decided at this stage? Whether there has been a violation of an ad interim order of injunction or not. If you want me to go into that, I can go into all those, whether it's at this stage.
My lord, there are two orders, my lord. One at 139, my lord, and then later at subsequently, my lord, 142. 142, my lord.
Yes. The order is status quo with regard to the nature, character, and possession. Show me from this order how it has been decided with regard to the status quo. What was the status as on the date of passing of the order? Show me this.
My lord, it says the record is taken.
So if you have to, if you all want to invite me to go into those, I have to make observations on this order of status quo. Whether this type of an order can be implemented. That is why. So this as vague as that, status quo as it is, as it is.
My lord,
Nobody knows what was the status, whether the pipeline was on that date or not on that date, whether it was a cultivable land or there was a multi-storied building. Nobody knows.
My lord, it says, my lord, the brief facts of the case. My lord, 142, my lord, has
142.
142, my lord.
Yes.
I already dull it down.
This is, my lord, the second paragraph. My lord, the brief facts of the case is that the plaintiffs are the owners of the suit property through inheritance, whereas the defendants are strangers who are.
Where is the plaintiff of this suit? 1713 of 2024.
Well, the plaintiff is at my lord, page 131.
No, 131 is the plaintiff of
another suit. 1689.
There are two suits. Show me the plaintiff of the other suit. This is 1689 of 2024, and this order is of 1713 of 2024.
Page 20.
This is between two private parties, Devporon Bera and and Gale India. Where is the plaintiff? Show me.
I'll just point out. Annex. Well, it has not been annexed, my lord.
Yes.
Plaintiff. It's not there, my lord.
Please approach the civil court. It's the best forum which can adjudicate all your rights. Implement, punish them, punish their officers for violation of the order of injunction, arrest, detention, everything. Have wide powers. Here only consideration, they will say, no, we have not violated.
My lord will kindly pass that.
Ashun. The petition obtain this order, I will make that observation. It appears to be so.
Item 13 is a possible, my lord, but I do not see the learned advert for the state, my lord. Item 13.
What ছিল তো?
No, no, hold on. The
13, who is appearing?
my lord, he is, my lord, my learned friend, my lord, appearing today, my lord. He is,
Passover?
my lord, he has for the day.
For the day. Passover for the day. Yes.
All right.
Next.
Number 20.
Yes.
Was utilized by the state authorities for public purpose by excavating a canal. Excavating canal. The premier ground of litigation order pursuant to the direction of
Excavating a canal.
canal on my property.
Impugned order dated 17th of June. Where is that?
Yes, page 63.
Page 62, this order has been passed by the implementing authority. My lord, exceeding jurisdiction but not vested under law. He has determined the classification of the land and ownership of the land, ignoring the report of the BLRO which said that classification is Sali and I am the owner of it. You kindly come to page 68, the conclusion portion, conclusion and order. And may I please, as requested by Sri Roy, CS ROR and RS ROR, as also CS Mosa map and RS Mosa map were called on. Upon consulting those records, the plot was found to be a serpentine canal or khal. In the LR Mosa map, the plot is already reflected as a serpentine canal or khal. I find considerable force in the argument advanced by Mr. Roy to the effect that the Moser map shows the true nature and classification of a plot. So the ROR of a plot must align with the Moser map. Thus, the Moser map should be given precedence over the ROR of the plot in case the ROR differs from Moser map and any recording of classification of the land in the ROR which is not in alignment.
No, what was the issues?
Issues were there.
Solemn order, where is the order passed by this court, 9th of December
yes.
2024?
Page
53. Page 53.
53.
That 69 টা করে দিয়েছেন। No. 58 এর পরে 70 তো মনটা দিয়েছি। না না ভাই পরে দেখি।
नहीं 69 नहीं।
এইটা
এইটা নিন আমি আপনাকে সাহায্য করছি কনক্লুশনের পরে এই পেজটা এইটা 69
What was the plot in question? 1167 of by 1300? Where is the record of rights?
Yes, kindly even before that, page 21. My father purchased the same. Page 21 is the date. And my lord, the schedule at page 24. 24, my lord, second line 1164 by 1300. Kindly see, my lord, classifications Hali. As you know, got it right.
Yes.
This was executed in the year 1968. Then, my lord, page 25, if you also kindly comes. This is
Page?
20, next page.
Yes.
This RS record of right.
Government land.
My lord, this has been recorded in the name of the erstwhile owner Ayub Mullah. Then, my lord, next page, page 26, 1167 by 1300, Jomir Sreni Sali. Then, my lord, next page, page 27, Ela record of right 1167 by 1300, Jomir Sreni Sali. Ela record of right. Thereafter, my lord, page 28B, if you lordship kindly have a look. This is the earlier RS record of right, but from whom my father purchased. Earlier owner was Mohammad Ali Noskor. Classification is stated as next page, my lord. Classification stated as Sali. 1167 by 1300. Jomir Sreni Sali.
Yes, Mr. Mukherjee, what is your instruction?
And so far, the BLRO has filed a report. Kindly see, my lord, the report of the BLRO.
Yes, where is
Page-
that?
Page 50.
50.
50. But pursuant to the report of the BLRO, the video has said, apropos above, you are hereby informed that a khal has been excavated on the following royalty land as verified by BLRO, Canning 1, in your jurisdiction.
Who has excavated this khal?
Implementing agency, but who has passed this order, impugned order? That is, my lord, respondent number. Respondent number, my lord, 9. 9. So, my lord, the video has sought for the fund details, scheme details, etc. at page 50. Now, in reply there to page 51, the Panchayat has said this was not excavated by the Panchayat authority. This was excavated by the implementing agency, which has been written there, WBADMIP. Page 51.
Page 51.
Yes. As per the scheme code available on the site, it came to know that the said scheme was taken by WBADMIP West Bengal accelerated development of minor irrigation project and implanted by the district project managing authority. Then next page 52. Kindly have a look.
Yes, Mr. Mukherjee, what is your instruction?
My friend is concerned that he has no authority. Kindly see the order passed by the December court on page 53, 9th December 2024.
9th page.
Page 53.
Yes.
Petitioner is a minor, son being represented, minor resident claims to Honorable that the complaint is that though the plot of land canal has been constructed by the respondent for, the land has not been acquired, neither complete paid for it. Referring page 47, the petitioner submits the land on which was okay. Though that the petitioner shall serve a complete petition along with the 2 days order upon the respondent number 4, then upon issuing notice, hearing the same day, after granting the opportunity of hearing, decide the issue of right of petition by passing a reasoned order.
Yes. But what was that? Only directed to take a reasoned order.
Yes. But kindly see the order.
Yes. Project director is directing the revenue authorities to correct the record of rights. Yes. He has directed that. How can that be done, Mr. Mukherjee? Show me the authority of the project director.
No, kindly see,
Mr. Mukherjee, please kindly come from page 69, conclusion and order. He comes to the conclusion, map is wrong, this is right, correct the record of rights. What authority under what provision of law?
69 has not been supplied to me, but I have got a copy from the department. Paragraph 3. Paragraph 3.
Paragraph 3 of page 69.
Yes.
Yes.
I am also agreement to the legal proposition advanced by Sri Rai to the effect under the West Bengal Estate Acquisition Act 1953. Certain lands like forest, hart, bazaar and river have come to the vested in the state, and that a khal is no different, particularly when the khal serves as a water body catering to the irrigation needs of the adjoining irrigation land. I also find on account of such vesting provision of that, a substantial portion of the land that is for 50 decimal yards is already recorded in the name of government of West Bengal in the LR or order. I therefore appears to be a fit case for correction of the record of right. But that does not mean he is the authority. The government has taken.
How can he decide this issue? Show me under what provision of the statute he has the authority to decide this. Which is that vesting, map is wrong, that is right. Show me the authority.
Then High Court should not have referred the matter to the.
Mr. Mukherjee, High Court has referred to on what point? Please see. What was the allegation?
Yes.
He has transgressed his authority.
54.
Please, page 53.
53.
Yes. What was the complaint? The minor son claims to be the owner of a plot of land. The complaint is that the said plot of land a canal has been constructed. So this was the issue. He was only directed to decide whether on this plot canal was excavated or not. He should have stopped at that, whether canal has been constructed or not. And did he consider all these documents? The prior documents which have been annexed starting from page 47.
In that table, I shall have to find an affidavit.
These documents were not considered. The block land and land reforms officer, who is the authority, he is saying it has been excavated through a Rayati land, and he is saying, please correct the record of rights. What authority he has to say that?
The record of rights to be corrected by the revenue authority.
Mr. Mukherjee, what authority he has to refer this? When the block land and land reforms officer, can he page 49? It has been said that canal has been excavated on a Rayati plot.
But it is a finding by the project officer report.
Can he decide on these issues? That is wrong, please correct. When he is directing correction.
No, he has no power.
Yes, correct. To correct the record of rights. Fit case for correction of the record of rights.
No, that will be decided by the authority.
No. Appears a fit case for correction. So that the entire plot is recorded in the name of West Bengal. Nature of classification is to be synchronized with the physical status. What authority he has to say? What remains for the block land and land reforms officer to decide? If this is set aside, Mr. Mukherjee, everything goes. This reasoned order goes. That is the only reasoned order. If you say he has not said, authority will decide, then I am setting aside these portions of the findings.
No, no.
Then the rescinded order goes.
Yes.
Then if you say that no, he has not directed, then I'm setting aside this.
No, no, 51(4), government has taken steps.
But why these observations? Why these findings? I'm setting aside this, quashing this. Then your rescinded order goes. That's the only foundation of the rescinded order.
No, no, according to the entire plot, the member government was strong and destroyed the classification, consider the physical condition and Mojaba.
Yes.
That has been.
Is he the authority?
No,
He
no,
consider
he has forwarded the.
All right, I'm setting aside. He cannot forward. Show me the authority under the West Bengal Land Reforms Act. Suo moto correction of the record of rights.
No, 51.
Mr. Mukherjee, correction of record of rights either has to be at the instance of a party or suo moto.
Or suo moto.
Suo moto, who has the power? Please show me this project director has the power.
No, revenue officer 51A4.
Who all revenue officers do not have the suo moto to.
For specially empowered revenue officer.
Mr. Mukherjee, please tell me who is the authority to.
Revenue officer. He must be a revenue officer.
Not of every rank. There's a particular rank who can exercise this power.
Notified.
Each authority. So can he direct that no, please do that?
But in that amendment, 51(4) is there. Question is whether this RIT court will decide or whether tribunal.
Not a question. Without jurisdiction, project officer, in the light of the directions, could not have recorded this finding. Could not have recorded this finding.
Who will decide this question?
That I do not know. Who will decide, I do not know, but he did not have the authority.
Representation দিলে consider করবে তবে হবে
তখন
BLR কে দেবে
Director of Land Record. Upon the respondent number 4 to consider. You should have preferred to the matter.
Yes, direction was that on his property this was being excavated.
No.
So he should have only decided yes, whether on his property it was excavated or not. Now he is saying yes, it has been from the, because the record of rights speaks otherwise. Mr. Mukherjee, please consider this. Record of rights, everything. There is a presumption of correctness at the record of rights.
114 of the Evidence Act.
So there is a presumption of correctness. So on that basis, he said everything. Now saying correct this under what authority?
Then
that
High Court ought to refer the matter to the Director of Land Record because he is the.
Mr. Mukherjee, that was not the issue before the High Court also. High Court, the only complaint on a Rayati plot, a canal has been excavated. And rightly from page 47, the authorities have admitted those facts. See from page 47.
Yes,
authorities have, BLRO himself has admitted this. Who is the authority according to you to correct the record of rights? He has admitted on a Rayati plot this has been done. So, the authority empowered to correct, he is saying this.
It's 50-50.
Starting from 49, all pages. Everyone is saying, lastly, Pradhan saying, I have not done anything. Please don't catch me, I have not done anything. It's done by some other person. And then that person says, correct the record of rights, do that, do this.
54 per month, whether the block development officer has got any power.
For what?
For this.
50-50.
For what?
For
yes, he says
physical
inspection
excavated on the following Rayati land as verified.
Yes, because he is concerning
in a judicial. You are directed to provide the information, found details, scheme details, and excavation. Further, you requested to look into the matter, take necessary action earliest.
Yes, yes.
It's a block development officer.
Yes.
2022. Block development officer to Pradhan of the Gram Panchayat.
Yes.
Then page 51.
Yes.
Purpur Gram Panchayat. As per later by memo dated, I understand they informed that
yes, he said Panchayat did not excavate.
Then, as per scheme board available on the site,
yes,
that same scheme was taken by the WPMD West Bengal Accelerated Development Minor Irrigation Project and implemented the District Magistrate Authority. Then, regarding excavation of panel, page 52.
Yes.
Where's the copy of Pradhan? Pradhan has no right.
No. Pradhan has no right, but it's the block development officer who writes to the BDO because Mr. Mukherjee, the allegation was that the Panchayat has done that. Allegation was that
Panchayat. Panchayat said no, I have not done.
Panchayat. Allegation was that the Panchayat has done that. That gave rise to the cause of action of the earlier petition. court directed the project officer to do. Now the BLRO, he finds it's on a Rayati plot. He writes to the BDO because BDO is the authority under the Panchayat Act. He has written, please see the sequence of these letters. He writes to the BDO. Then BDO writes to the Pradhan because
the project director has already requested the government of West Bengal to exercise the power under section 51(4).
how can that be done?
No, 51(4) government, but if something is there, 51(4) can be exercised by the government, not by this project director.
Show me that he has the power to refer.
No, 51(4) will be exercised by the revenue authority, land department, not by the project director.
Project director cannot have, but show me these observations. He has the authority to decide this. And setting aside these findings, let the government decide everything because he has recorded these findings. After that, Mr. Mukherjee, what remains for the authorities to decide? Please see
2 and 4 is for
C1, paragraph C1.
সার্ভে বিল্ডিং আর হচ্ছে আপনার ব্লক অ্যান্ড ল্যান্ড লেভেল অফিসার
Order would have been if the order was passed by the Supreme Court directly the director of land record because he is the authority. So for records of the land is concerned in West Bengal.
What?
Which record is correct?
Please kindly come to page 68, conclusions. After this, what remains to be decided? From E1 to E4.
As requested by Mr. Rai, CS RS record, Bojo were called for upon consulting the record. The plot was found to be the serpentine canal. The plot is already reflected as a serpentine canal or car. Then,
এখানে পুরো কনক্লুশনের পরে আরো ঘটনা দরকার এরপরে
This plot was recorded in the name of whom? In the record of rights?
During course of hearing, petitioner contends that the master father registered Kamra deed purchased the land in question. Therefore, the petitioner father, by virtue of gift dated 2014 with the additional district register, Matla has transferred the aforesaid land to the petitioner mother. Then, the land is a right to land contention. Thus, never acquired, not in acquisition procedure. Contention of the counter contention made. Per contra, Amitabh Rai, executive engineer, submit that as far as the inquiry, the plot in question has been a canal since time immemorial, serving as a water body catering to the irrigation needs of the adjoining plots. Says the plot appears to be naturally occurring serpentine creek and must be a canal or khal. In the previous record, that is to say, CS and RS record are consulted. He requested the CS record.
The issue that arises for consideration in
এলেই হবে, এখন কাউকে শুনবে এখানে তো পড়বো।
Sir, therefore said CO number such and such stands dismissed as not maintainable, leaving the petitioner free to work out his remedies in accordance with law. If recourse to any proceeding is taken by the petitioner, it would be open to the opposite party to raise objection on all counts which may be available in law. Can accordingly stands disposed of.
Great. And I'm formally praying for stay. My lord will. Report it.
Dismiss executable order. Dismissal of a writ petition or civil revision application. Stay, there is no executable order. If there's an executable order, stay prayer may be necessary.
My lord, there was an order of injunction in force, restraining them. If my lord stays it for a limited period, at least
Order of injunction?
There was no.
Where is the order of injunction?
And my lord, there was, if my lord sees the record, it said that since they submit that they have not taken out an execution application, therefore I am not.
Execution for what?
My lord, they treat this, I mean, they've now gone to the NCLT and are treating this
So
as
that's a different
for
thing
execution of this order.
No,
This
no,
is
no, no,
nothing
no,
but
no,
an
no.
execution
By this, it was only the civil revision application has been dismissed. Question of stay comes when there is an executable order. Here, none of the orders is under challenge.
Submitting that since there was a so-called order of restraint, then if this order was stayed, that would remain alive till I was able to conclude. My lord, in any case.
The learned advocate for the petitioner. Civil division stands dismissed.
না লাগে তো না।
Yes. Call the next matter.
Item number 21. Lordship, item number 21, Mr. Bishwaidde is appearing for the petitioner.
Who is appearing?
Mr. Bishwaidde.
Not today.
Praying for a short pause.
Not today. Next.
Item number 22.
Not today. Next.
Item number 23.
Lordship, item number 23, I'm appearing on behalf of the petitioner, Your Lordship.
Yes.
Appeal to service developer. 23, behalf of respondent KMD.
Yes. KMDA.
Yes, Your Lordship.
By Mr. Satyajit Talukdar.
Yes. What is this matter?
Your Lordship, this is the affidavit of service, my lord, first I'm filing.
What are you challenging?
My lord, I'm challenging a demand made by the KMDA. My lord, the demand is at page 133.
Demand for what?
Demand for developmental charges, Your Lordship. My lord, we are a developer. We have entered into an agreement, a development agreement with the landowner.
Yes.
We have, my lord, he's there with me, my lord. If Your Lordship permits, he can make submissions, Your Lordship.
The petitioner is a company who is in the process of constructing a residential premises, several towers. This is situated in Barakpur area.
The Town
In
and Country
respect of
Planning
these
Act.
towers, there was a all sanctions, respective permissions, everything obtained. Around 16 of them obtained from 2022 onwards. My lord, now there is a with regard to the permission, there is one last demand which we have received on 9th of September. My lord, that demand, my lord, kindly
You are
comes to me.
challenging that demand.
I'm not, I'm challenging it in the sense with regard to the quantum of that demand.
Yes.
My lord, there are three facets in that demand. If my lord kindly comes to page 133.
133, yes.
Yes. My lord will kindly see that there is for institution of use. So my lord, there is a demand of 2 crore 12 with regard to institution of use. There is a demand with regard to change of use, which is 85 lakhs, and for carrying out other development. Now, and before this, my lord, in the same notice, my lord will see that, sorry, no, my lord kindly takes up the page before. My lord will find that this is a residential project. All my correspondences, everything indicates that this is a residential project.
So residential project, according to you, these charges cannot be levied.
My lord, not at this quantum. There is, I will show the notification in terms of residential use. For institution of use, there is a requirement of rupees 50 per square meter, whereas in respect of commercial use, it becomes 375 per square meter. My lord, 375 has been applied against me despite the fact that my use is residential.
Yes, Mr. Talukdar, what do you say?
My lord,
Kindly come to
and may I only indicate this for institution of use, my quantum comes to approximately
No, have you
28 lakhs.
have you raised this point by way of a representation?
Yes, my lord, I have done that. That representation is at page 134.
Any decision on that?
No, my lord.
Mr. Talukdar, decide that, because
before that, if your lordship kindly come to
I'm late.
paragraph
yes,
paragraph 5
paragraph 5 of
5 of the writ petition.
writ petition. Yes.
Writ petition. The what for the use.
Yes. According
They-
to you, it's commercial.
They are developing. They are developing for selling it to individuals. So there will
So
the
according
use
to
is
you, it
use is
commercial
commercial.
from their point of
Their
view.
point of view.
But
Though
even though
residential
the nature of user of the property is residential.
residence, but what they are doing the commercial venture.
Three pages, not page 150, 151 and
Mr. Talukdar, this type of permission, it's for a large area, for development of a large area. So there are two aspects: one, an individual or a group of persons owning a particular plot of land, uh, developing it for their own purpose, or yes, for their own purpose, maybe one thing. And if it is a large chunk of property, a large tract of land,
For commercial
yes,
activity.
So according to you, if someone, developer, by the name developer, what is
Developer,
commonly
here
known,
the
if
developer.
he comes, then he has to
It
fall
will be
under this
treated
category.
as commercial use, institutional use. Here the rate, he is agreed by the rate.
There are two ways of looking at it. One, the petitioner says that they have given a representation raising all these points. Have you
Yes.
taken a decision on that? It's one way, because if once the decision comes, it might be easier to consider whether, because you also make up your mind, you disclose your mind, what is passing through your mind with regard to these issues.
Now, this is being
Very simple. The KMDA cannot go, he's a planning authority. He cannot go beyond section 103 of the Act, Town and Country Planning
So
Act.
you are challenging the authority.
No, not authority. No, they have raised a demand which is devoted section 103 of the Act.
That
And you have
is
raised
not.
in the representation.
That
Mr.
is not.
Consider that, take a decision. I think otherwise keeping this exchanging because this has to be by way of an
No,
affidavit.
the law says not when
No,
once it is defined with some
representation.
residential purpose in the act, and the purpose being residential, whether it can be interchangeably used.
That's
That's the only
issue.
point.
So you decide that issue. I think once you take a decision, the
Lord,
scope.
it is in identical cases. My lord, we used to charge this. It is not that we have discriminated with the petition.
That you may have your points.
Yes.
You may say yes for ABCD reasons. They are liable to pay at this rate.
There are
Mr.
notifications.
Majumdar has raised certain points which, according to him, you cannot charge at this rate. You decide that.
We have they are challenging that
Yes.
decision. My lord, we have raised this demand in accordance with law, in accordance with the provisions of law.
Consider the issues raised in the representation. It was not occasion to
Representations.
Not may I
Further,
submit?
if you want, then only that will delay.
Not may I submit only one thing? Not your lordship is on page 1. Your lordship has seen page 133 probably.
134.
133.
133, yes.
Not there are few heads of charges.
Yes, that
One-
learned friend has pointed
Yes,
out.
1,
This
2, and 3. Not there is a dispute with regard to the first head.
Only a first aid.
Only first aid.
No, please see. One is 2 crores 12 lakhs. No, that's the dispute. But this is 28 lakhs 37,503 if it is for residential purpose, depending on the area, which I have to pay. Not for change of use, it's 85 lakhs. Not 1 partly and 2 in full. 2 is dependent on the first one. Now this is in dispute. Not I pay off the other development charges, although this is not on any basis. Third minute, I'm paying it off to them straightway without raising any dispute for the time being. So not out of 3 crores 21 lakhs, kindly permit
So
us.
according to you, conditionally, they will grant you. That might be.
But it's after all not the project is stuck. Not if
That
you have
is-
to.
That is why I was asking Mr. Talukdar.
If your lordship,
if you can consider
Not
these
we-
points.
we have 51 lakhs
we
and not-
have considered. Lordship will find from the page 133. If your lordship, may I read this?
For the time being, we pay 51 lakhs. Not
For the
start the
time-
work. We let
that
them
we-
give a professional.
No, that-
If we lose, we pay off the remaining amount.
That we, lordship, kindly read this.
That will.
The
create
development
a-
proposal.
It's not going.
because you
It's
are undertaking a large project.
Yes.
Not going to be ended in 2 months' time.
Whether that is
6 months' time.
permissible or not, I'm showing your lordship to only two.
Provisional this.
Court's order. Court's order.
No. That. Lordship, kindly have a look. Kindly have a
First
look.
of all,
Whether authority,
obtaining no
any
objection
officer,
certificate for change of user.
whether any officer can concede to this or consider in view of this paragraph.
All right, then I will direct filing of the report. You file a report, I will consider that.
Page 133, lordship, first 2 line.
Mr.
Kindly have.
Talukdar, there were 2 ways of looking at it. If you say yes, the authorities cannot consider, I will call for a report, I will decide that. And if you say yes, you will disclose your reasons, then that can be considered. It's either way.
Not this being a charge, no
There-
officer
there
will
is-
take the
there-
responsibility.
there-
Lordship can well
No,
appreciate.
there is no scope.
The
mentioned
Yes.
in the morning. My lord, there's extreme urgency in the matter. My lord, my livelihood is at stake. Not being able to pay my employees, my business has come to a standstill, my
Who is
lord.
appearing for the other side?
I've already served notice, 2 notices, one
Who is
yesterday.
appearing?
My lord, Mr. Shubhashata Banerjee is appearing for the private respondent, and Chandana Ghosh is appearing for the state.
What is the extreme urgency?
My lord, my livelihood, my restaurant has been closed down, my lord.
Since when?
Since 14th of December 2025, my lord. My lord, not being able to pay my employees, I'm not getting any. My lord, kindly considers, my lord.
The other side is not here.
My lord, I've served notice, my lord. We'll intimate through the course of the day. Kindly fixes a date, my lord. Any date, my lord, any date.
The list, Monday you can move.
My lord, top of the list, then lordship.
Monday you can move.
My lord,
My lord.
instead of 19, can it be on 18? Or any day after?
18th is Sunday. You will be available, all right.
Without seeing the
Your lordship will continue after the decision.
20th.
20th.
20th January.